to Basics, Abuse and Neglect Proceedings 101, our third cross-training session of 2021. The topic today is Disposition Hearings and Permanency Planning. My name is Kristen Antolini, and I'm joined today by our presenters Teresa Lyons and Natalie Sal. Both Teresa and Natalie serve as guardian ad litems as well as counsel for adult respondents. Before we get started, just a few basic housekeeping items. For our attorneys, today's presentation provides 1 hour of CLE credit. The provider is the Supreme Court of Appeals of West Virginia. For our social workers, today's presentation provides 1 hour of CEU. You will be able to find the CLE and CEU code at the end of our online survey. The link to complete the survey will be provided in the chat box, and we will also send an email with the survey link and a copy of our PowerPoint presentation following today's session. Your feedback in our online survey assist us in planning future sessions. Our next lunchtime session is on May 14th at noon, featuring the Honorable Cindy Scott of the 17th Judicial Circuit and members of the West Virginia Coalition Against Domestic Violence. The topic is a new tool available here in West Virginia to help assess domestic violence called SAFER. And I've been using it in some of my cases in anticipation of this session that we're going to be sharing with you next month. And I've really found it helpful. So I hope that you will consider joining us next month for this new program that's available to us. It will be allocated for 1 hour of CLE credit, and we are working on obtaining CEU credit for our social workers. We ask your patience today if we encounter any technological issues. We are streaming from all different counties in the Mountain State. We also encourage you to utilize the chat function to both ask questions and provide resource information for your colleagues. Please send your questions and comments to everyone. Finally, please note that our session today is being recorded. So to get us started, Teresa, we're going to be talking about procedural prerequisites, timelines, purpose, and possible outcomes of a disposition hearing. And just to kind of get us started, that, where do we find basically, Teresa, the code sections that govern disposition?
Primarily, you're looking at 494604 C and D. C and D it's a long statute, so it goes down to C. Start with C.
And once we get past that part of kind of checking there first to maybe read the code, which I think is a good place for everyone to start to get an idea of what happens at disposition, can you tell us a little bit about what are the procedural prerequisites that have to be in place before the disposition hearing can even occur as outlined in that code section?
Well, the first thing that has to have occurred is there must have been a finding of abuse or neglect. In other words, the adjudication hearing must have been conducted and there was a finding of abuse and neglect. There's the 2011 case, KCM, that I have cited there is one of really speaks to that issue. And that issue, the department filed a petition against a father. However, the department then, before adjudication, asked for dismissal. In turn, the circuit court, based solely upon the best interests of the child, not on an adjudication of the father, went ahead and placed the children, primarily the mother, and the Supreme Court indicated, again, you cannot move to disposition if you, in fact, have not adjudicated a parent. And that was the same holding of AP1, which is a case involving an incarcerated parent. And in that case, the father had, the department had not proved abandonment. The incarcerated father had, in fact, paid some support out of prison wages and also maintained cards and I believe had phone contact. However, at disposition, the court went ahead and terminated his rights, and the Supreme Court again kicked that back and remanded the case because the father had not been adjudicated in that case. So there must have been an adjudication. It's just a fundamental principle of these cases. In terms Go ahead, Kristen.
Yeah, what else has to happen as a procedural prerequisite? Thank you.
In terms of, there's some things that need to be filed. Now, for guardians ad litem, they should file their written report 5 days, judicial days before the proceeding. The child's case plan should be filed 5 days before the proceeding, and that's the department's responsibility to get that in. And then all parties are supposed to file Rule 30 disclosures, and that's witness and exhibit disclosures 5 days before the hearing.
And does the department engage in some dispositional staffing prior to a disposition? And what is a dispositional staffing, Teresa?
In that case, it's an internal meeting in the department with the child welfare consultant, and the department worker will work with them and determine what their recommendation is going to be with regard to disposition.
And when we look at the overall timeline of a case, of an abuse and neglect case, where does the disposition hearing fall in that overall timeline?
The first place that it can fall is following an adjudication hearing, and then it should be 45 days following adjudication. If there's been an improvement period, then it should be 30 days after the completion of an improvement period. Parties can agree to go straight to disposition. It's called an accelerated disposition. However, it's really a matter of local practice. In some counties, they'll go straight to disposition. In other counties, they won't go straight to an improvement period, and we'll get to that. The reason to perhaps delay and use that extra 45 days is to build in more time for parents. And so that's a consideration as to whether you should go straight to disposition or not.
Teresa, what if we have an unknown father? What if we've had to plead an unknown father and we're going to have adjudication? If the parties agree, does it sometimes make sense to maybe have an accelerated disposition in that case to accelerate the permanency for a child?
I think that's a good example of going to an accelerated disposition.
And you almost touched on this, but sometimes we'll hear these phrases, initial disposition or a final disposition. What is the difference between an initial disposition and a final disposition hearing?
Typically, initial disposition is referring to the fact that you're considering whether or not a parent would be able to obtain an improvement period. And that could be, and we'll get to that on another slide, but down below, deep in that same statute, it talks about, after it goes through all the different sorts of dispositions, it says the court may, as an alternative, grant an improvement period. So that is where we get the term initial disposition.
Okay. And let's say that we're at initial disposition and I have a client who an improvement period motion or even a final disposition. How do I know whether it's a post-adjudicatory improvement period or a dispositional improvement period?
Typically, the party should indicate, the party asking for the improvement period should ask for what type of improvement period they want. Typically, you would want to go to a post-adjudicatory improvement period because the dispositional improvement period is a second one. So if you want the possibility of a second improvement period, you really need to go go to a post-adjudicatory improvement period.
And digging a little bit deeper into, what do we do at a disposition hearing? What is the real purpose of a disposition hearing? I mean, I think sometimes we think it's, to terminate or to return, but does the disposition hearing have some other purposes and some deeper purposes than just that?
Well, the purpose is one that the disposition hearing does is it alters or determines the relationship of parent to child going forward from that day. And that's really what's important. You'll determine, there are a lot of things, we'll break that down and get to that. However, that is fundamentally what it does, is it determines what the relationship between parent and child will be like. With regard to that, what's reviewed is the child and family case plan, and also wrapped up in that is the permanency plan for the child. The court should be considering that and maybe determining what that permanency plan is at the disposition hearing.
And what if, Teresa, what are some of the possible dispositions that a court may consider? And can you kind of teach us about, what if a dismissal is not appropriate, but a termination is not appropriate either? What are all the options available to the court and the parties?
With regard to that, there's a list of the possible dispositions, and those are listed in the order that the court should consider. Now, dismissal typically is reunification and the case is over. However, perhaps you need to return the child home, and that's disposition 3. But you still want some supervision, and that may be with the case open or the case closed. So that's a possibility. Disposition 5 is when technically it's when the child is committed to DHHR for a specified period of time. However, it's typically used if a child is placed with a relative and the permanency plan is going to be a guardianship. So that's a disposition 5. And then finally, termination of parental rights, which is the most drastic outcome, is considered. But again, you have the whole range of possible dispositions when you're dealing with considering what to do about the relationship between parent and child.
And Teresa, is it fair to say that you would encourage M.D.Ts to really get together prior to disposition and talk about, maybe using a 2, a 3, a 4, a 5 as the lesser restrictive alternative, and really brainstorm and try to get some ideas for what is going to be best for these children?
Absolutely. I think that's where it's best. And if you can avoid, if parental rights are going to remain intact, it's better to not burn as many bridges. So sit down, help the parents create a permanency plan, create an agreed upon disposition. And I think and the department and GAL come to an agreement. It saves a lot of time. You end up with a disposition that is not cookie cutter, that fits the case and the facts.
Yes, absolutely. Hey, Teresa, we have a good question. Are there limits or in terms of supervision which can be ordered, or does the court have full discretion in that area under a disposition 3?
There's no limit to what the judge can issue. And again, typical things might, if you have an abusive parent, perhaps that parent has to stay away. That's kind of a typical thing that I've seen. That particular disposition isn't used much, but it might be some sort of services that they want a parent to participate in. And if they don't participate in that service, it may trigger coming back to court.
And what if the court is considering a dismissal under a disposition 1? What are some considerations on that topic?
Well, you want to look at the details and facts of the case. And one thing you need to consider is that a non-abusing parent should have the right to custody of his or her child. So again, you need to consider, what will that dismissal look like? It doesn't mean, just because a parent has gone through an improvement period, it doesn't mean if there's a second parent that child is automatically returned to the parent who was successful in their improvement period. It may be that it's in the child's best interest to stay with the non-abusing parent. Again, you have to look very carefully at the facts. If you have a battered parent, that battered parent, the parent who was the victim of domestic violence, he or she can have be awarded sole custody of the of his or her child.
Thank you so much, Teresa. We're going to switch over to Natalie, and then we're going to be back with you, Teresa, for permanency planning. Hey, welcome, Natalie.
Hey, thank you.
And we're, Natalie, going to be talking a little bit about parental rights, and I appreciate you joining us today. Just to kind of get us started, I mean, we're always talking about reunification. That's always the goal in these cases. However, is there sometimes when the M.D.T and the court is just not required to seek reunification? Can you tell us about that?
Well, absolutely. A reunification should be the goal in most cases, but there are cases where reunification is not required and those efforts and services are not required. And those are actually set forth in 49-4604. When you have cases where you have a parent who has committed crimes against another child, or crimes against the parent of their child, or in cases of sexual assault, sexual abuse of a child, those kinds of cases do not trigger that requirement in the department to work towards reunification.
What are some times, though, what are some other times when the department is required to request termination? Can you tell us about that?
Well, absolutely. If you have a child who has been in foster care for 15 out of the last 22 months, the department is required to request termination. Now, let me give you a little caveat on that. The best interest of the child is always going to be the guiding star here. So there are circumstances where children are in care that long, and nonetheless, it still is in the best interest of the child to reunify. But department policy will require that they seek termination or ask for it. And of course, the court will consider that when determining what's in the best interest of the child. Those are going to be exceptional circumstances. Those timeframes were put in place to try and assure permanency for children within a reasonable period of time. If you don't have permanency, you don't have safety, and you continue to have a child who's in a position where they're unsafe. So those are going to be extraordinary circumstances.
Now, we had a question in the chat real quick. Would removal of a sibling qualify, or does it have to be a crime in what you were just talking about?
Well, removal of a sibling will trigger removal of a child, but it does not necessarily trigger a request for termination of parental rights. It's going to depend on the circumstances. So what the statute says is that you don't have to try to reunify. The department can specifically, as mandated, to specifically request termination if there's a crime that was committed against a child or another child in that home. There are also circumstances that are so egregious where the department is required to seek termination. Those are going to be circumstances of abandonment or torture, sexual abuse, or when you have a parent who has murdered a child in the home, or a sibling or parent. Those types of circumstances are deemed so egregious that the department is relieved of its burden to try and seek reunification of this family, and they are mandated to request termination of parental rights.
And so when we are going to have a termination, what is the statutory standard for terminating parental rights?
The statutory standard for terminating parental rights is whether or not there is a reasonable likelihood that the circumstances of neglect or abuse can be substantially corrected in the near future. And that's the question that the judge is going to answer at every single termination hearing. That's the question you should be considering going into every single termination hearing. And when you look at what really those mean, near future does not mean can this be corrected if we're given an additional year or 2 or 3. Really, we're looking at a fairly discrete period of time. Again, short time frames, because safety requires permanency happen quickly for these children.
And just to dig into this just a little bit deeper, Natalie, what does the no reasonable likelihood that conditions of abuse or neglect be substantially corrected? What does that really mean?
What that really means is that when the court looks at the evidence before it and it decides that the respondents do not have the capacity to solve the problems of abuse and neglect on their own or with help. If that is the circumstance, then that means that there's no reasonable likelihood they're going to be able to substantially correct those conditions of abuse or neglect. And you can find that actually in the code. Look to 494604D.
So are these some of the conditions that maybe you were referring to?
These are some of the conditions that I was referring to, and this is not an exhaustive list by any stretch. What we're seeing a lot of, sadly and unfortunately, is we're seeing a lot of circumstances where respondent parents are abusing substances and it is interfering with their ability to effectively and safely parent their children. And if that cannot be remedied, substantially remedied in what is considered a very short period of time for the purposes of substance use treatment, then that will lead to termination. Refusal to participate in the family case plan or to participate in necessary services, those are bases where termination is going to be sought and would be warranted. Additionally, when you have circumstances like abandonment, when you have serious or repeated injury, a battered child syndrome, when you have sexual abuse, when you have those types of circumstances, they are, because of their nature, not going to be circumstances that can be substantially corrected within a reasonable period of time.
Let's say that a parent is participating in medically assisted treatment. Does that fall into one of those conditions? Can we terminate if that's kind of the only issue, Natalie?
If that's the only issue, we absolutely cannot terminate. There is not any, in fact, there's a prohibition against termination if that is the sole problem. Now, of course, those types of programs can be very helpful to some folks. Other folks will engage in those programs, but they continue to use. That's a separate issue. But if the sole issue is that they're in medically assisted treatment, then the court is prohibited from terminating parental rights based on that alone.
So just in your opinion, Natalie, what if, one of these many border counties that we have, someone is going over into another state and participating in medically assisted treatment? Do you think the court has any authority to say, hey, we understand that you need this medically assisted treatment, but we want you to come into the state of West Virginia for this treatment? Do you think the court has any authority on that issue? And does that play into termination at all?
That has been a big issue in a lot of cases along these border counties where I practice. And certainly the court has the authority to suggest, but as long as this is a medically assisted treatment program that is an actual qualified, valid program, the court does not have the authority to say that they're not going to allow somebody to participate in that medically assisted treatment. Here's the problem, though. In those treatment programs, it is extraordinarily difficult, in my experience in the counties where I practice, to have medical personnel available who will make themselves available to provide reports, to provide records, to come and testify or to testify via remote. Getting them to come in to present evidence is very, very problematic. And that can be critical if you have a respondent client who is trying to demonstrate to the court that they've been addressing their substance use problem through one of these programs, and they have really no expert and no evidence to back up what their claims are because they won't come across the border or can't come across the border to testify. The other issue is services. It is an issue of payment. Getting the department to pay for services across those state lines is problematic at best. And so having somebody who can participate in a program in state allows for payment of services if those funds aren't otherwise available to respondents, and certainly allows access to records and to the providers so that we can make sure that everything stays on track.
And we had a question, Natalie, and just one last question on this topic, that, what if the use of that medication is preventing the parent from being capable of parenting? Is there still a prohibition? I would think that kind of takes it into another realm, that it's not the sole issue anymore. But could you provide some feedback for us on that question?
I would agree with you entirely. If use of that medication is impairing a parent so that they cannot safely and adequately parent their child, that's a separate and a different issue. And that would be akin to somebody who is prescribed a medication for any other purpose, but that particular medication also renders them incapable of parenting. And it may be a physical issue. It may be because they have brain fog from the medication. It may be a number of different things. But any medication, if it's rendering somebody incapable of safely parenting and they've not made arrangements so that their children are appropriately cared for, that's a separate issue than medically assisted treatment. And that is an issue that leads to an abuse and neglect finding if it's proven.
Thank you, Natalie. And we have a question that I'm just going to encourage people to kind of answer in the chat so that we can move on, Natalie. And it says, how do you determine if the medically assisted treatment is credible? How do you determine if it is a credible program, not a pill mill? So I would just encourage people to kind of give their thoughts on the chat and that. And Natalie, we're going to move on and talk about what are some parameters in regards to the termination of parental rights, if you can speak to this.
Well, absolutely. The court is going to certainly want to look to less restrictive alternatives, but the reality is that the court is not required to exhaust every single possible alternative to termination of parental rights. Again, you're going to use the best interest of the child as the guiding star, and you're going to look to whether or not the burden of proof has been met with regard to whether the abuse or neglect can be substantially corrected in the reasonable future. And so the court, in looking to that, is not required to go out on a limb and try one after another options before terminating. The court is going to also consider the circumstances of the individual child. There are no cookie cutter cases. So when you're looking at children who are very young, who are at a tender age, 3 years and under, children who have special developmental needs, children who are going to have special circumstances and require greater care, they need to have full commitment or fully committed adults who are with them and who are raising them and who are parenting them. And in those circumstances, you're going to not want to subject them to extended periods of trying one after another things. You're not going to want to subject them to anything but a very permanent situation if indeed the abuse and neglect cannot be substantially corrected. So for those types of circumstances, termination of parental rights is usually going to be in the best interest of a child.
Speaking of our children, the most important part of our case is, when does the court consider the child's wishes in regards to final disposition?
Well, the court's going to consider a child's wishes when they are over 14. I can tell you in my experience, I have courts who will also consider a child's wishes when they're younger than that, if they are extraordinarily precocious, if they're very bright, if they're very mature for their age. But in terms of the code and the guidance that's offered, children who are 14 and older, the court is going to consider their wishes. And when you have a situation where parental rights have been terminated and you're looking at adoption, a child who's 12 or older can say, yes, I want to be adopted, or no, I don't want to be adopted. So they're given a great deal of deference in terms of their wishes for those situations. You're muted, Kristen.
Thank you. So both to Natalie and Teresa, I wanted to just mention a question that's in the chat. It was about our slide back that we were just discussing about this parameters in regards to termination of parental rights. And the question is, what if I think a child basically has special needs and we need to provide, some services in that regards to assist reunification. The question is, so the court is really looking at what the child needs and whether there is some type of assistance that the parent can be given to meet the child's needs, question mark, not what the parent needs to be better. Do either of you ladies have any thoughts on that question?
I've had that come up in cases. And one of the things that we tried to do as an M.D.T. when we were exploring reunification, and I can tell you, I've had some cases where we've been able to successfully reunify in those circumstances, and others where we have ended up at termination of parental rights. What we have tried to do is, first of all, to address the core problem of abuse and neglect and see if indeed those circumstances can be remedied. But then we also look to what services can we put in place to provide additional training and support to the parents to deal with the needs of a special needs child. And there have been circumstances where the needs were so profound, very profound health needs, that termination was necessary because this child needed such specialized care that these parents were not capable of providing it even with assistance, and they were not capable of being able to parent this child because of that. And the court saw that as an extension of, are they able to remedy the conditions of abuse or neglect? They were not able to remedy the conditions of neglect because of the circumstances and because of their own limitations. That's the way the court saw it in that circumstance. I'm sure Teresa's probably had these cases as well. Teresa, you're muted.
I would say I'm waiting for Candy to unmute me. That's what happened. What I would say, I think your answer, Natalie, was very thorough, and that's what I would say. I realize that it's difficult, but there are situations where a child may have special needs such that the parents really cannot care for them, and that's what you're looking for. Can the parents provide all the needs of the child with or without assistance, without court supervision going forward? And I think that's what the court has to answer in those cases.
Thank you, ladies. Natalie, we're going to just really briefly talk about voluntary relinquishments and just kind of backing up a little bit to what we talked about 2 weeks ago. I'm going to briefly take you back a step to the adjudication hearing. What if a parent just says, you know, it's in my best interest and the child's best interest for me to relinquish? Can a parent do that at adjudication? And what are some considerations to keep in mind?
A parent can do that at adjudication, and obviously, there are a number of considerations to keep in mind. First of all, the relinquishment must be accepted by the court, and to do that, the court is going to look to the circumstances, to the terms that are in the relinquishment itself, and they're going to look to make sure that the respondent fully understands what they're doing. By entering into a voluntary relinquishment, this is a permanent situation. They are at that point relinquishing all rights to that child. And that means the right to know what is happening in that child's life, and the right to contact, and the right to have any direction in making decisions for that child. That terminates that relationship, it severs it. So the court's going to want to make sure that those relinquishments are voluntary, that they're knowing, that you have spoken with that client at length and they understand what they're doing, and that they understand that they can't just change their mind a month down the road. Those are all important things. This is why best practice would require that these be in writing. There's no legal requirement that they be in writing. They can be taken orally. But if you're going to take one orally, you really want to make sure to make a clear record and have that client, have that respondent put testimony on the record so that you have covered all those bases and they have a full understanding, and they have let the court know that they have that full understanding. Best practices would require, though, actually having a written voluntary relinquishment rather than doing this orally unless there are exceptional circumstances.
And Natalie, if somebody wants to provide a voluntary relinquishment, and let's say they haven't been adjudicated yet, isn't it true that the court can use that voluntary relinquishment as a basis of adjudication and adjudicate them through the acceptance of a voluntary relinquishment, so that it's not just a way to get out of being adjudicated?
That is absolutely true. So if the client's concern is, oh, I don't want an adjudication on my record, so I'll just relinquish, this is not going to be a way that they can do that. It's still going to, it still could be considered to be an adjudication used as a basis for an adjudication as well. And that can be fairly critical for folks who, for whatever reason, they may have personally, be at work or whatever, they don't want to have an adjudication on their record.
Thank you, Natalie, for joining us. Please stay with us so that if we have some questions in the chat, you can help us out with that. Thank you so much. And we are going to move on to permanency planning with Teresa. And Teresa, just some basic questions. When does permanency planning start? What's the concurrent planning? What's really the definition of permanency? Tell us about this.
Well, I have heard social workers say that it should start, permanency planning should begin the day the child comes into care. And I very much agree with that. And again,
it's day one, right?
Yes, day one. You want to think. Now, concurrent planning is just plan B. And so what we ask in those cases is the placement that's serving as their temporary placement, are they willing to also step up and be the permanent placement if the parents don't? And that's what concurrent planning is. It's defined in the statute, it's recognized, and it's best for children. I think it's harder on both parents and foster parents, and that includes relative placements, but it really works. So in terms of permanency, what's the very real definition of permanency? You guys might want to tell me in the chat. I talked about it a few years ago, and we came to the conclusion is, who are you going to call at 2 a.m. if you're in trouble? That's permanency. Who do you want to be there for you when you need somebody? So again, that's what permanency is. And really, in this case, when you're starting to deal with permanency planning, really what you're looking at is well-being for the child and permanency. Again, you've moved past adjudication, you've moved past disposition. So
Teresa, just before we move on, I want to ask you, whose responsibility is it to engage in the permanency planning? I mean, is it the GAL? Is it the department? Is it the foster parents? Is it everybody?
It's everybody's responsibility. Even biological parents, respondent parents may well say, I understand I have a problem and this is where I'd like my child to go. That's a very loving act, and it's supportive. The GAL needs to work on it. The department needs to work on it. And we have a statute about relative placements now that requires you to look at it very early in a case. And again, you really need to think about where you're going if things go south.
So if you've got a place at the table as an M.D.T member, let's say you work with one of our wonderful foster care agencies and permanency planning has not started, people should speak up and say, hey, like, what about permanency planning? We need to get this started and not just wait until disposition.
And that's exactly right. Again, you need to be, I think getting to permanency when you supposed to, and we'll get to that slide, is a matter of being very proactive and thinking about what are we doing when everybody in the M.D.T goes away, and that's the goal. That's the goal.
So when we look at the statute, how is permanency defined?
Permanency is really defined, if you look at it, it's return to the home with no custodial supervision. Now you can have some supervision, but not custodial supervision. And then you could have placement with a relative, and that's kind of an older feature in the statute, but that is contemplated by the relevant statute. You can also have permanent sole custody with a non-offending parent and maybe with visitation. Again, and then you can have what's called permanent out-of-home placement through adoption, legal guardianship. Now, emancipation is listed in the statute. I have never had a child emancipated, and again, I question whether it's really the best thing to do, but it is in the statute. People can age out of foster care, and then finally, there's what's called another planned permanent living arrangement.
And as you mentioned, I kind of jumped ahead in my to a slides in my excitement to talk about permanency. But ultimately, I mean, who makes that final determination about the permanency planning? Is it the court? Is it the M.D.T? Is it the court with a recommendation from the M.D.T?
It's the court with recommendation from an M.D.T. And again, I know that seems sort of basic to say that, but really in the last 15 years, that's been developed. Prior to that time, there was something in the department called the Adoption Review Committee, which has since been disbanded, and they're not doing that anymore, but it is a judicial decision. And if there's a conflict as to which particular family, that's decided by the court. Now, it doesn't mean that other members of the M.D.T don't have an opinion and a position. It just means the entity or the decision making falls with the court.
It's fair to say, you know, just when we're thinking about our cases from day one, I mean, is it fair to say we don't want to necessarily put all our eggs in one basket, and we kind of want to have two things going on all at the same time? We want to have this one area where we're all about reunification, and then this other area where we're thinking about what is an alternate area of the case, and we all have to do that all at the same time, kind of with the same goals in mind. Is that a good way to put it, or is another way maybe more helpful?
No, that's a great way to put it. That's a description of concurrent planning. Concurrent planning is, and again, you know, you just want to look at that. Foster parents have a right to participate in this. Pre-adoptive parents or a custodial relative, they are to be involved in permanency planning, as well as respondent parents if their rights have not been terminated.
So as far as the judicial piece, Teresa, when does the court hold a permanency hearing in our cases?
Again, you do this if you're in one of these aggravated circumstances case and the court makes a finding that the department is not required to make reasonable efforts to preserve the family, then the court should conduct a hearing within 30 days of the time that it makes that finding. The second time is within 12 months of the child entering DHHR custody, and every 12 months thereafter till permanency is achieved. Now, it doesn't mean that a parent may be out of time and you may not have everything done, but for funding purposes, for legal purposes, the court does need to have a permanency hearing within 12 months of the entry into foster care.
And at a hearing about permanency planning, are there any required judicial findings that must be made, Teresa?
Yes, for the child to still be eligible for Title IV funding, which is federal funding for foster care, the court needs to make a finding that the department is making reasonable efforts to finalize the permanency plan in a timely, and that's the reason for the court making that finding in a particular case.
And what are some of the other considerations that the court must consider during permanency hearings?
Well, you have to look at the appropriateness of the educational placement, whether there's services needed to get that child to permanency, whether you're looking at another planned permanent living arrangement, and whether or not reasonable efforts have been made to reunify, or is it a case that there's no reasonable efforts required? And again, you want to look, has that permanency planning been done.
And we also, of course, talk about transition to adulthood, consideration of sibling relationships. Can you talk with us a little bit about that?
Yes, again, the court needs to consider, is this placement that the child is in, is that the best placement for that child? Is that where the child's going to stay? Their special needs, whether or not they're going to be placed with their siblings or not, transition. And a big thing, if there's been a delay in transferring the case to the adoption unit, perhaps that's what the court needs to address. What needs to be done to get this case to to get the child into a permanent home?
And speaking of transfer to an adoption unit, I know that's an issue that comes up a lot in my cases. I mean, what's a reasonable amount of time for a case to be transferred to the adoption unit? What should we be looking for?
You know, I think it takes so much more time than I think it should. The first thing you have to consider, you have to let the appeal period run for a parent if there's been a contested disposition. So the earliest possible time is within 30 days after disposition. Typically 6 months is relatively reasonable. When you start going to a year, I don't think that's reasonable. And when I see that in my cases, I start asking for a specific time. Now, one thing I would just mention is use your guardian ad litems. As guardian ad litems, we keep records. We're used to keeping records, and we can get to records. And I often will supply any missing orders, or I'll go get orders. So I encourage department workers that ever need any assistance with that to ask me.
Absolutely. So let's talk a little bit more within permanency planning about the preferences per permanency. And our foster care ombudsman kind of mentioned this in the chat a few minutes ago. What are the preferences for permanency, and where do we find those in the code and the case law?
Yeah, in the code and the case law, I've listed them on the slide for you because I think this is, again, it's a very difficult determination. What I would say first is not one of these preferences, the grandparent preference, sibling preference, or relative fictive kin preference, not a one of them is in fact absolute, and they are always subject to the child's best interest. With regard to the grandparent preference, Elizabeth A. indicated that, again, yes, when there's going to be a situation that's not good for a child, but it's with a grandparent, the court isn't mandated to place there. Again, PF, which is very new, 2020 case, that the court said absolutely that's where that child should go, is with the grandparent. The same issue is with regard to siblings, and there's a very recent case from this spring 2021 where the question was a child with some special needs was in a foster parent, whether the relative and fictive kin preference and the sibling preference mandated placement absent best interests.
And how do we factor our children into the permanency period, into the permanency hearing? Are their wishes considered? Can they come to the hearing? How does that work?
Well, the statute, which is 494608, actually contemplates the child coming to a hearing unless they're waived, or if the children is less than 12 years or would suffer emotional harm. I don't see that often, but certainly the guardian ad litem, the therapist, the caseworker should have talked to about what the child wants well before the hearing. And the one thing I would point out, if APLA is considered the permanency plan, the court needs to ask the child if that's what they want. There's a woman named Samantha Sizemore who's spoken to us, and she graduated from foster care. And she said, you know, I was asked one time when I was in foster care about whether or not I wanted to be adopted. I said no that one time, and I was never asked again. So again, you want to look at, you want to talk to the child, and I encourage it not to be a one-time talk. Oh, we're losing Kristen. With regard to that, the question is, when should permanency be achieved? And Rule 43 indicates that permanency should be achieved within 12 months of final disposition. I know that there are cases that go on beyond that, but again, a lot of this can be dealt with by being very proactive in your permanency plan.
And when should permanency be achieved?
Oh, I just answered that question.
Sorry. I lost a little bit of internet over here in the Circuit Court of Preston County. Did you also talk about when is it appropriate to dismiss a case?
No, I haven't gotten to that one. So,
all right.
Again,
so tell us when it is appropriate to dismiss a case.
Again, it's only appropriate to dismiss a case when permanency has been achieved. And the reason for that is that if not, children tend to get lost in foster care, and they're not in a they may not be getting what they need, and they may be entitled to something, or the family may be entitled to something. So again, permanency needs to have been achieved. That's why you wait till after an adoption, you wait till after a legal guardianship has been established. You don't dismiss until everything's been done.
And just really quick before we wrap up, someone asked a good question. I'm assuming very young children do not participate in a permanency hearing. You know, what is kind of the age, or is it based on their ability to communicate and understand? Can you help us out with that?
It's really based on the child's ability to communicate and understand. But again, the statute plainly indicates that if they're 12 or older, they're supposed to attend unless it's waived. I don't see that happen too much, but certainly the child's wishes or opinions should be considered.
We have a link online for some additional reading that we would encourage you all to take a look at if you're interested. We really appreciate you joining us today. Our CLE provider number for our attorneys is 54190. The link for both social workers and attorneys can be found at the end of our survey. We hope that you might consider joining us on May 14th at noon for a special presentation from our coalition about domestic violence, about the new tool in West Virginia, the SAFER assessment. And also on June 11th, we'll be streaming live from Logan County about sibling separation, and hope that you can join us. We hope that everyone has a wonderful day. Thank you for all of the hard work that you do for our children in this glorious state, and have a wonderful weekend. We will see you soon. If you have any questions for our panelists, please put those in the chat, and we'll hang out for just a few minutes to answer those. Thank you so much. Bye-bye.
Did we lose Kristen again?
It looks like it. Yeah, she's.
I'm here. I'm here.
Okay.
I'm here.
Are you getting the questions I'm sending you?
Let's see. They're like, people are responding, and so it's like filtering it up. Let's see. So if dad is terminated, but DHHR has not filed allegations against mom, can the GAL file an amended petition? Yes, a GAL can file an amended petition. I file all the time. I probably file more than anybody I know, so yes. Someone mentioned that the Bureau for Child Support Enforcement recommends addressing child support in all major stages of litigation. It assists in clarifying the parent's responsibilities and helps to ensure orders are in an appropriate amount based on the circumstances. Absolutely. Someone asked about how they can register for upcoming workshops. That information is actually, I believe, and Candy, correct me if I'm wrong, it's on the Supreme Court of West Virginia website now. Those links are provided there for everyone. And then of course there'll be emails as well. And we have, I don't know if the link to register for the sibling separation training is up yet. I do not believe that it is, but it will be June 11th from 12 to 12:50, and then we'll have an extra expanded session. So basically a beginner session at the noon hour and then an advanced session in the afternoon hour, and we'll have that information coming out. And yes, we will send the slides out. Hopefully I answered all the questions that are there.
I think so.
And sorry about the internet. I should have probably put it off my phone, but it seemed to be working pretty well over here today. So I was like, oh, I'll go with the county internet.
Oh, that's just one of the risks of doing stuff online, but it's okay.
The risk of rural practice in West Virginia.
Right. We all live with that.
That's right. Candy can actually send you the recording link. Ma'am, I see that question in the chat.
Because I missed the CLE code.
It's 54190. And also at the end of the chat. I mean the survey. All right, I think that's it. Thank you, everybody. Have a great day. Thank you, Natalie.
Thanks,
Thanks,
everybody.
Natalie.
Guys.
Good to see you.
Good to see
Bye.
you.
Thanks, ladies. Have a good weekend.
Thank you.
Somebody asked about provider printed certificate for CEUs or just the provider number. And I think that's a Candy Greeter question.
Mhm.
Christopher, if you need a certificate, you can just email me and I will email you a certificate that has all the information on it. Also, when I send out the slides, I will remind everyone if they need a certificate just to email me. So.
And I just sent you the slides.
Perfect. As soon as I get the attendee list, I will email everybody.
Thank you. Bye.
Thank
you.
See ya.
See ya. Have a good day, Natalie.
Thanks, you too.